Hello, my name is Neslo Attila, and I am the Counsel of Record for Team 16773, representing the petitioners.
Hello, I'm Kaylee Mathis.
Okay. First question, why is social media so important today?
Social media is so important today because of globalization that it brings. This globalization allows people to be connected through the entirety of the country. It also brings 24/7 news, which allows people to get resources and information from across all platforms and all ideologies. It also allows social networking, and it is protected under certain laws.
Social media possesses certain freedoms which make it more similar to a common carrier than anything else in legal history. Social media has protections which dissociate the freedom of speech of individual users from the freedom of speech of the social media platform the user issues an opinion from, which then allows these social media platforms to have massive growth over time to become the massive conglomerates now seen today. These social media platforms are used by the vast majority of the population of the United States for anything from dissemination of information to social networking to things like social or legal information. And overall, the social media companies play an extremely important purpose in modern society.
All right, question number 2. How does the Florida law restrict social media platforms' ability to engage in content moderation by removing, editing, or arranging user-generated content?
The Florida law restricts social media platforms' ability to engage in content moderation by preventing unhinged content moderation or any content moderation which is unexplained. The Florida law establishes that content moderation, which includes things such as shadow banning, preventing a user's posts or information from being seen by the general population, banning, preventing a user from use of the social media platform, or moderation, removing a user's content from the social media platform without explanation. By preventing these things, the Florida law establishes a content moderation principle which requires explanations of any content that is moderated. In order for content to be moderated or removed off the platform, the content moderation will have to fall under the policy and approved policy of the social media platforms, and a user must be issued an individualized explanation of exactly why their content was moderated and given an opportunity to remedy this moderation. Social media platforms have to be transparent about the rules and policies of their content moderation, which does not restrict their ability to engage in content moderation. Rather, it requires stricter standards for content moderation, which then allows users to enforce their freedom of speech by offering their individual opinions throughout social media platforms and knowing that their content will not be censored unknowingly.
Question 3, how does the Florida law require social media platforms to provide individualized explanations for certain forms of content moderation?
In the event that content is moderated on a social media platform, the user will experience a set of steps. First, the user will receive an email explaining, or a message explaining exactly why their content was moderated and what specific content was removed from their profile. Following that, the user can access the social media platform's policies, which determine what content is allowed on the platforms and what content is limited, and then can compare the contents of their post with these policies. If a message or an email is not sent explaining why a user's content has been censored, shadow banned, banned, or moderated, this goes against the Florida law. Individualized explanations ensure that there is a reason for all content moderation and allows users the freedom to fight back if and in the event that an unreasonable action is taken by the social media companies toward their content that they create on these social media platforms.
All right, question 4. Why did Florida enact its social media law?
Florida enacted this social media law to increase transparency and openness. With today's day and age, more people, especially political candidates, are going onto many social media platforms to be very open and engage with the public about their policies and their ideologies. Because of this, a lot of social media platforms may be shadow banning certain undesirable candidates, and this law will help these political candidates because an explanation will have to be given on why this has happened.
With a rise in political maneuvering that is now done online, social media platforms take the position of public forums and could often be considered common carriers of information similar to telegram lines or telephone lines, in that all users are able to participate in the use of social media platforms and the dissemination of information that is necessary to a way of life. Political candidates and varying ideologies have had a great rise as social media use has risen. And with this, social media platforms and companies often take certain stances which they are not fully open or transparent about. Because of this lack of transparency, social media platforms may deplatform, moderate, or ban individuals or certain content that they do not agree with, thus inhibiting users' freedom of speech.
All right, question 5. What tier of scrutiny should the court review Florida's law with?
The court should review Florida's law with intermediate scrutiny for 2 reasons by government policy. It must serve an important government objective and be substantially related to achieving the objective. This law fulfills both of those requirements.
This is because the government objective that it serves is upholding the freedom of speech.
And it is substantially related to achieving this objective because it prevents unnecessary or unexplained content moderation of social media platforms and mandates an individualized explanation in the event that content moderation does happen. This enforces users' freedom of speech, particularly in the state of Florida where the law has been adopted. And because it serves an important government objective of upholding our First Amendment right of freedom of speech, it allows for the law to pass under intermediate scrutiny under the Supreme Court.
All right, 6. Do social media platforms resemble newspapers, which can control their editorial content?
Social media platforms do not resemble newspapers, since newspapers have to go through a lot of tiers of editing and many differing opinions until it is released into the world. While social media, many of the times, is just the user's personal opinion without any moderating or editing or anything like that. So each user and individual has their own control of their own words and their own content.
The social media platform has no influence or control over the information that an individual user puts out on the social media platform, whereas in the event of a newspaper, as several Supreme Court precedents have held, newspapers go through several tiers of review in order to put out content that aligns with the ideology or beliefs that the newspaper represents. In comparison, social media platforms represent no particular ideology, as they are composed of several million individuals all sharing their own opinions, personal facts, or stories. Because of this, social media platforms do not resemble newspapers and more commonly could resemble common carriers in aiding in the dissemination of information and in allowing for freedom of speech and of action. And while newspapers are sources of information and opinions, social media platforms are more similar to public forums in which each individual can have their own say.
Question 7. Does the compelled speech doctrine protect the rights of social media companies?
The compelled speech doctrine does protect the rights of social media companies. Compelled speech has been constitutional in many precedents of the Supreme Court over the years. Compelled speech does not interfere with the company's freedom of speech for several reasons. The company's freedom of speech allows for the companies to put out any ideology or any belief that aligns with their values. However, their freedom of speech does not extend to limiting other individual citizens' ability to put out their own content, whether or not those ideologies or ideas are opposing the social media platform's ideologies. Each individual user provides their own content, and so each individual user exercises their own freedom of speech. The companies compelled speech does not interfere with the company's freedom of speech because the compelled speech, as seen in several other court cases, does not interfere with First Amendment values of efficient communication and limiting harm enforced by speech. On the contrary, the compelled speech doctrine protects the First Amendment rights of users while allowing the companies full range of their own freedoms. The users are able to keep their freedom of speech and their First Amendment rights, while the companies are not limited in their ability to put out any content which they may believe in, and yet the companies are limited from inhibiting the freedom of speech of social media users by performing unnecessary or uninhibited content moderation.
Question 8. Do the social media platforms engage in commercial speech?
Social media platforms do engage in commercial speech. However, the majority of commercial speech is so dispersed and individualized that it's not really. This can be seen with many accounts from businesses and even other apps. However, because it is so individualized, users often disassociate the commercial business from the individual post.
As seen in Pruneyard Shopping Center v. Robbins, and in the instance that a public forum or a forum owned by a company, such as the shopping mall in the court case, has individuals expressing an opinion which does not align itself with the values of the mall, it is taken as a precedent that typical individuals can infer and are able to come to the conclusion that those individuals and their ideologies automatically do not align with the mall's. Thus, even though individuals express certain ideologies, the overall values of the mall remain strong and stable. In a similar exhibit, when social media platforms do engage in commercial speech, such as speech which will allow them to make more money as corporate conglomerates, this commercial speech is automatically separate from the commercial speech or the ideologies put forth by other users. While users also engage in commercial speech on these social media platforms, for example, businesses, other corporations, government, and more, this commercial speech and whatever ideas that this commercial speech may enforce have no relation to the commercial speech put forth by the social media platforms. Thus, the social media platforms are not losing on income due to ideologies or ideas put forth by other users, and the social media platform's revenue stream is not interrupted.
Question 9, will the Florida law increase or decrease free speech on social media?
The Florida law will increase free speech on social media because often censorship and banning and political bias runs rampant through social media, and this law will help limit the amount of censorship done because it forces an explanation to be given, as well as limiting content moderation.
By limiting this content moderation, it increases the amount of free speech that users may exhibit and experience. Users putting forth their opinions on social media will no longer have to worry about being unnecessarily censored or having no explanation as to why their content is being hidden, removed off the platform, or moderated. This freedom of speech will allow for all individual users of large social media platforms to fully exercise their freedom of speech while preventing the limitations on freedom of speech that may be seen in harsher censorship laws or anti-censorship laws put out by the government. The social media platforms retain their own freedom of speech and freedom to moderate any content they believe is inappropriate, so long as they provide individualized explanations, which are constitutional under Supreme Court precedent. And the users of social media platforms also retain their own freedom of speech by being allowed to put forth any ideology or opinion that they may hold.
All right, question 10. Does the Florida law create a slippery slope towards censorship?
The Florida law does not create a slippery slope towards censorship. On the contrary, if the Florida law were overturned, this would create a slippery slope toward uninhibited censorship by social media platforms of any opinions put forth by users that the social media platforms feel their values do not align with. It may be an argument by the respondents that social media platforms, that this law being passed would result in a slippery slope towards censorship by social media platforms, in that it would limit any censorship social media platforms may experience and completely prevent the existence of censorship on platforms, thus allowing for rampant ideologies and communities to form. However, this is unrealistic. Social media platforms are still able to engage in a certain level of censorship while now being required to provide individualized explanations for this censorship, thus allowing users a wider range of their freedom of speech. If this law is overturned, it will result in a slippery slope by providing a Supreme Court precedent that censorship of companies toward weaker individuals is legal, supported, and more than possible. Because to rule in favor of the respondents to declare prevention of such moderation unconstitutional would create a slippery slope of permissible, unregulated censorship in online platforms. On the contrary, by continuing to pass the Florida law, it not only prevents a slippery slope toward unlimited censorship, but secures the freedom of speech and First Amendment rights of social media users. Thank you.
Thank you.